What the agents of the defense have done is they have gone out and interrogated 400 citizens of Latah County. That is reckless conduct, and it's outrageous.
Fighting words in the Bryan Kohberger case as the defense reaches out to potential jurors as they try to get a change in venue.
There are two things that have happened without me being able to even weigh in that's done when the prosecutor asks you to do something. And I don't like that. I want to have opportunities to be heard.
Judge is not happy after the defense claims that he violated Bryan Kohberger's civil rights.
I told you that I was going to set a hearing. So I don't know what your understanding is with just the process.
There were some recent fireworks in the Bryan Kohberger case, and it all stems from his lawyers wanting to move the trial out of Latah County. Bryan Kohberger's lawyers hired someone to do a survey of potential jurors in Latah County after University of Idaho students Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xana Kernodle were murdered in an off-campus house in November of 2022. The reason for the survey? To see how tainted residents of Latah County might be against defendant Bryan Kohberger. Prosecutors say that the defense conducting a survey is not a big deal, but what has them upset are the questions the trial consultants asked the 400 residents when they called them up on the phone.
Have you read, seen, or heard if Bryan Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred? Have you read, seen, or heard if the cell phone tower data showed that Bryan Kohberger made several trips near the victim's home in the month before the killing? Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Bryan Kohberger was arrested for the murders? Have you read, seen, or heard if Bryan Kohberger said that he was out driving alone on the night of the murders? Have you read, seen, or heard if Bryan Kohberger stalked one of the victims? Have you read, seen, or heard if Bryan Kohberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication evidence expected to be presented, evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial.
Now, much of this information has already been put out there to the public, but prosecutor Bill Thompson argues that that doesn't matter. It still violates the non-dissemination order, an order that Ann Taylor requested. Here's what Ann Taylor has to say about everything.
This court and counsel knows how much coverage this case has received. And he does what he does by looking only at what's in the public. We didn't provide him any police reports. We didn't.
I'm sorry. It's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides, to protect a fair trial, okay? And our concern from the very beginning was all the media stuff floating around, okay, that affects your client, Mr. Kohberger, to get a fair trial. And some of these questions actually create a concern about, that they're inculpatory. It could be prejudice for his client, okay? And that I'm just surprised that both of you didn't come together and say, there are certain things that we probably shouldn't put into the public on a telephone call. It really concerns me, and that's why I did what I did that.
Now, Ann Taylor says that she did not approve the questions, but she did approve the topics, and the survey is anonymous. Well, things got pretty heated when the defense claimed that Judge violated Bryan Kohberger's due process rights by halting the survey.
Now I'm being accused of violating a due process, which is a whole big issue for me.
I can understand that would not be taken. I have to represent my client to the best of my ability. And the reason for that, Your Honor, with all due respect, I was shocked to see the court issue an order within hours of the state filing a motion late on a Friday without giving us a chance to be heard.
My order didn't say it was permanent.
Maybe
And it told you that I was going to have a hearing.
maybe I phrased that very poorly. It's a decision that you already made.
Okay, let's go back. I got the motion at 4:30 on Friday. Now, it doesn't even reflect, just when it was filed, because Odyssey has a delay, right? So I get the motion at 4:30 Friday. I get a response from you at 4:45 Friday, right?
I don't know what time you received it, but I filed an
That's when I
objection
got
the
it.
minute I could.
Because then you know that about 5 o'clock, that's when I issued that. So I had a half an hour. I read the materials that were attached to the motion that the state filed, and I had very little information. But it seemed like there were some real legitimate concerns about the survey. And obviously, it turns out there are concerns, legitimate concerns about what was done in the survey.
Oh, the boys. Well, Ann Taylor did say in her motion to rescind the halt of the survey that she felt that Judge and Bill Thompson were basically having discussions and making decisions behind her back, which, as you know, are something that you just do not do in the United States judicial system. So here are how things ended with that survey.
Judge, I'm confused. What are we going to have a hearing on?
Well, I want to see what thoughts you all have about dealing with the situation now, making sure that we can salvage anything or nothing. And Ms. Taylor's going to talk to Mr. Ellman, and maybe that'll give us some thoughts. Otherwise, I could just make the decision right now, but I'm no expert about surveys.
What do you think about this issue? Is this another means the defense is trying to employ to be sneaky and getting information out to the public that may not otherwise be admissible in court, that they might not find out through court proceedings? In other words, is this the defense's attempt to taint the jury pool, or is the prosecution overreacting? So let's take a look at some other times historically that Bryan Kohberger's defense has done this during the pre-trial phase.
Tonight, a bumpy start to a lengthy court battle from the defense team of alleged Idaho murder suspect Bryan Kohberger. His team attempting to force the surviving housemate of the four-slain University of Idaho students to testify in his defense at a preliminary hearing in June. That roommate, Bethany Funk, is fighting against it, filing her own motion to quash the subpoena in Washoe County, Nevada.
And newly unveiled court filings are shedding light on how the defense team for Bryan Kohberger is trying to play things out. In the filings, his defense asserts that a surviving housemate has exculpatory evidence, information that could be favorable to Kohberger.
According to the court documents, Kohberger's defense team says she has, quote, information unique to her experiences and cannot be provided by another witness. Funk is fighting the subpoena. Her attorney filed a motion saying even if her client has exculpatory evidence, which remains unknown, quote, there is no place or reason to present that evidence at a preliminary hearing.
As we all know, that preliminary hearing never happened because the state convened a secret grand jury and, well, history in this case had been made. However, I think along the main goal of this motion to compel Bethany Funk's testimony in the pretrial hearing was for Ann Taylor and her team to get information out to the public and to the potential jury pool that there might be exculpatory evidence out there. I mean, how else would you be able to do that with such a strict and broad gag order in place? It truly is amazing to think about the amount of information that the defense team, Bryan Kohberger's defense team, led by Ann Taylor, has managed to get out to the public, to the masses, to potential jurors in the midst of a strict and broad gag order that has been in effect since January 5th, 2023. So let's think about one of the first times that we heard from the defense in a big way and a way that made headlines. And that was the defense's motion to compel Bethany Funk to testify at the pre-trial hearing. So what was the defense's reason for compelling her to testify in that pre-trial hearing? Well, according to what they had to say, it was because Bethany Funk had exculpatory evidence that could, well, by the definition of exculpatory evidence, they're saying that could exonerate Bryan Kohberger. Exculpatory evidence is evidence that shows that somebody is not guilty of the crime for which they are charged. The person who is authoring this document introduces himself as an investigator that was retained by the defense for Bryan Kohberger. And I'm starting here at line 7. It says, Bethany Funk's bedroom was on the first floor. The other surviving roommate's bedroom was on the second floor. Bethany Funk was interviewed by police on several occasions. She disclosed things she heard and things she saw. Bethany Funk was present at the home 8 hours later when police were called, arrived on scene, and discovered the homicides. The statement in the document goes on to say, during the course of my investigation, it became known to me that Bethany Funk has information material to charges against Mr. Kohberger. Portions of information Ms. Funk has is exculpatory to the defendant. Ms. Funk's information is unique to her experience and cannot be provided by another witness. So what exactly could this exculpatory evidence be that the defense is continuing to allude to? Now, understand that the defense is under ethical guidelines that, according to the oath that they've taken to be an officer of the law, to be a member of the American Bar Association, they can't just throw out statements that are baseless, that don't have any foundation in fact or any kind of evidence that they are aware of. So for the defense to say that they believe that a certain witness has exculpatory evidence, it's under the scrutiny of the court eventually, if they choose for it to be under their scrutiny, to test the validity of the statement, at least the knowledge that the defense attorney had in making that statement at that time. So Ann Taylor is well aware that she is representing a defendant in a very high profile case. So unless she's going to put everything on the line, unless she's going to put this trial on the line and her career as an attorney on the line, we have to believe that Ann Taylor has a good faith reason to assert that she believes Bethany Funk might have, or she says has, evidence that may be exculpatory to Bryan Kohberger's guilt.
One of the things about being a lawyer and litigating cases is you have to know how to use leverage and use the tools in your toolbox. And when you feel like you have something, you have to use it appropriately and ethically in order to get what you want or need in a case.
Please leave a comment below letting us know what you think. We all want to know what you think. And thank you so much for watching this video. Please click like and consider subscribing. We would love to see you back.